All right, good afternoon, everyone. This is Mike Sacchi, and today's bull session is an ALRB refresher course on access and a cursory overview of how to deal with and investigate unfair labor practices under the labor laws. So this time of year, we start seeing a lot more access being taken. And as you know, that under the Agricultural Labor Relations Act, we have a regulation that provides for access onto private property once it's properly filed and activated and served upon a grower, or for that matter, a farm labor contractor. But it places limited time, place, and manner restrictions on the organizers. So any paper given to you or a supervisor that says it's an ALRB paper and it's a notice of intent to take access or a notice to organize or even a petition, those are time-sensitive documents and need to be immediately brought in to the company management, and you need to bring in counsel as soon as you can. So initially, we don't consider a notice of intent to take access. We don't consider that activated until a few things happen, okay? First, it's got to be filed with the Agricultural Labor Relations Board. Then it's got to be served upon the grower. Now, it can be served upon the grower and still not be active. And the way that you know something is active is it's been properly served. Upper right-hand corner of the document there's a diagram that looks like the face of a watch. That tells us that it's been filed properly with the ALRB and what time it was filed. That then activates their right to take access. Now, if they file against a grower, that also gives them access not only to the grower direct hires, but to also the farm labor contractor employees employed on behalf of that grower. So once access begins and is activated properly, you've been served and they begin to take access, they being the UFW, the Teamsters, let's say. There are certain times, place, and manners of their access. So times when they occur: 1 hour before work, 1 hour after work, and during the lunch period. Of note, especially with regard to workers that utilize voluntary transportation by growers and farm labor contractors, the buses typically are considered a place of congregation. So the 1 hour before and 1 hour after work, those organizers may be on your bus. Not when the bus is moving, when the bus is parked and acts as a congregation point. During lunch, we say during lunch, not 1 hour, because typically your lunches are 30 minutes. During those periods of time, supervisors must move to a neutral location. However, we want to be very important today about training supervisors. So access, whether we are dealing with lawful conducted access by a union or attempted access by an outsider, a stranger, an NGO, non-governmental organization, or even a governmental organization, you've got to have good training of your supervisors. We simply cannot allow anyone to walk into our field locations, our work site, our production facilities without an escort, since we are a high hazard industry. We have COVID protocols and practices in place, and we have food safety concerns. So there's the first line of defense, is your supervisors and getting them trained. Now, in terms of lawful access under the Agricultural Labor Relations Act, a union can only show up with a number of organizers permitted. For the first 30 employees, they get 2 organizers, and then for each increment of 15, they will get 1 additional organizer. So if you've got a crew of 5, they get 2. 10, they get 2. 29, they get 2. 30, they get 2. 31, they get 3. All the way up to what? 45. At 46, they get a 4th. So each increment. Now, organizers have to identify themselves and wear badges, take pictures of it. Organizers must identify themselves as a supervisor, request it, record it. Organizers may not disrupt operations. However, speech alone is not a disruption. Document all violations. Give me the date and time. Give me the organizer's name. Give me the nature of the violation. The nature of the violation back here typically is going to be they showed up early and took access without me allowing them. They stayed longer than the lunch period. If they wouldn't get off the buses and they interrupted our production. Okay. Those are the three top complaints of violations. Okay. So let's talk about meeting folks at the perimeter of the field and assisting in a viewable way the choreography that goes along with this dance that we call access. Once we have our supervisors properly trained on type, place, and manner, and what the organizers must do, then supervisors need to take it upon themselves, especially at the lunch access, to keep an eye peeled for organizers amassing at the road. Let the folks know that you're going to, as a supervisor, walk off and meet and greet those organizers. Go ahead and do so, meet and greet the organizers. Let them know they're a little bit early. We've got a couple minutes with lunch. And when we blow the whistle and people get comfortable, I will come and get you and allow you to take access, and I will go to the neutral corner. Why do we do that? Well, from the viewpoint of a worker, you don't ever want them to think that the union can merely show up and take control of your workspace, your work site. We are allowing them into our private property, into our production area, to take access under the law only after we check their IDs, we check who they are, we count the number versus the number in our crew, and also take pictures of that identification. And if we're smart, we're going to take pictures of their cars and their license plates and pass it along to council. So the reason why we want this information is because I've already started tracking for 2021 season. I've already started tracking access throughout the state. Who's taking it? What's the message? What's the purpose? And so far, none of the real bad actors or the real organizers have showed up. So the UFW, for instance, makes it a practice to send out a lot of college students during the summer. They bring them into 50 acres over in Delano, and 40 acres rather, and they train them. They have kumbaya sessions. They have a little camp out, and then they turn them loose on growers and farm labor contractors throughout the state. Those are not the ones that worry us, because all they're doing is blowing a bunch of programmed information through a bullhorn. Why we want license plates and vehicles is that tells me who's there. When I get a name of a specific organizer, then I know we've got a serious organizing effort, and that allows me to move my resources into position in case they start taking access on a serious level and start working their way towards a petition by getting authorization cards signed. So who shows up to me is more important than what they're saying, because who shows up tells me if we've got a serious threat. Okay, remember, things you cannot do. Basically, there's 5 things, tips: threaten, interrogate, promise, spy, or solicit grievances. Threatening. You can't tell people that work for you, if you talk to these guys, you know, you're going to lose your job, or I'm going to shut this damn thing down and we'll bring in a farm labor contractor to take your job. Interrogate. Asking them that what organizers said or whether they attended a meeting is an interrogation. Making promises. It's too late to make promises. Once access is taken, making promises is now unlawful and a violation of the Agricultural Labor Relations Act. What are promises? Well, look, I hear you guys are talking about wanting a 10-cent raise. Tell you what, tell all the guys and girls we'll do the 10-cent raise and tell the union to go hit the bricks. That's a promise, okay? Spying. Spying is figuring out who's attending meetings and why. That's why you hire us. That's why you hire our consultants. Those things are done legally by others. And then soliciting grievances, that's like a promise, right? Trying to figure out why it is the employees are talking to the union in the first place. Is it simply they feel that they don't have a voice? Is it COVID? Is it, gee, we should be getting paid more? Or like we had in Santa Maria last year during COVID, a lot of organizers came in after we implemented COVID-related harvesting practices that cut people's earnings because we were only harvesting every other row. So we started having union activity. Oh, big bad employers. Yeah, well, if people got sick and died, we'd be in worse shape. So there was a no-win proposition for employers, right? So we tried the best we could to flatten the curve of the COVID, but in doing so, our people lost some earnings because we slowed things down. We had hand washing stations. We had training every single day. We had temperature taking. And for some of us, we started harvesting in a different way, okay? So Access cheat sheet is available to you at this link, and we'll send it to you at the end of this seminar today. This is a great sheet. It's English and Spanish that you can get a hold of and train your supervisors. Okay, so let's talk about some wrinkles and what's going on around the state. So under California law, governmental agencies, unless they're complaint-driven or program-driven inspection, and the ALRB, they don't have a right to just come on your private property without checking in at the office and breaking all of our protocols. They typically will come to your office, your principal place of business, and at that time, we will provide them an escort if there is a reason to. The UFW, the Teamsters, they can only come on your property if they've got a properly served notice of intent to take access with the ALRB. Private NGOs, non-government organizations like the CRLA, CAUSE or MyCop, or anyone else, they have absolutely no right to be on your property whatsoever, okay? So this happens notwithstanding government officials like we had this last week with the head of our Labor Workforce Development Agency, Julie Su, who's our former labor commissioner, and at present is awaiting confirmation as the undersecretary to the U.S. Department of Labor as appointed by President Biden. She still holds a state position, however, and last week she tweeted with the help of her amigos at these NGOs that they were going to go out and stir up some shit with all of our workers. And that's exactly what they've been doing since last Wednesday. So we've got, let me get to that, agitators. So last week, she put out a tweet, thanks to our partners at Mistake-O, Indigena Community Organizers Project, MyCop, Central Coast Alliance for United and Sustainable Economy, CAUSE, California Rural Legal Assistance. So they've been roadside with a bullhorn, trying to program our workers on things that our workers have already heard from us 100 different times in 100 different ways on COVID protections, their rights under labor laws, et cetera, okay? So the fact that we've got a government agent out there clearly biased, clearly unfair, clearly targeting growers is what's changed really in the last couple of years. They're not even attempting to hide the less than neutral or lack of neutrality, less than fair or the lack of fairness and completely biased approach that they take. She oversees the Labor Workforce Development Agency. She is a neutral fact finder, overseeing neutral fact finding agencies, and she has no regard for the rule of law. She has no regard for the appearance of fairness or neutrality. She's going to partner up with her friends in the NGO community and bash us, bash our industry, bash our growers, bash everything about us. And then she's going to leave and she's going to go and become even a more powerful bureaucrat at the U.S. Department of Labor. These are the things we're up to. We have to fix this ourselves. We do that with training. We do that with identifying the types of access. We do that with training our supervisors on the various types of access. And we do that with knowing what rules apply to which type of access and having a plan to deal with access of all kinds, okay? So what if UFW, here's a union taking access under the guise of COVID-related compliance issue? That's not their issue. If they don't have an organizational purpose and a properly filed NA, notice of intent to take access, they can pound sand. If they have a notice of intent to take access, but they're taking access under the guise of COVID education, that lacks an organizational purpose. We will ask them to leave. and we will bar any future access. We've done it in the past. Social justice and government outreach. This is the alert that's still in effect for all of our clients on the Central Coast. And these are the you know, the NGOs and the players that are out there trying to agitate. And now they've got Julie Su walking in lockstep with them. Understand that your domestic workers may very well have been through this before, but all the more reason to really concentrate in a significant way, more so on your H-2A workers. They don't know what this stuff means, and educating those supervisors and those workers to ignore this stuff and giving them a voice in our company is very, very important. So now, what is it that I need all of our clients and our listeners to do that we're talking about access of all various types, and it could be lawful or unlawful? Well, first, let's start getting our signs and enforcing our perimeters, right? We've got COVID protocols, enforce them. We've got high hazard production operations and an IIPP to govern that, enforce it. We have food safety and we have a program, enforce it. We do that by signage, controlling ingress and egress to the property, and documenting unlawful entries to the property, and allow our lawyers to take the appropriate actions. Supervisor training, they need the access cheat sheet, dealing with visitors that we're going to go through here in a second. And then the last wrinkle. Last wrinkle is employee housing. You know, the ALRA regulation is a bit murky here because the ALRA kind of treats farm worker housing as the principal residence or domicile of that farm worker. Not necessarily true, because when you have a communal bunkhouse, one person allowing access to others necessarily and inevitably impinges on the rights of other workers in the group that consider them, that bunkhouse, theirs as well, and they're trying to get some sleep. The long and short of it is we are able to place reasonable time, place, and manner restrictions where appropriate at our labor camps, especially with the H-2A. What I've been telling all of our clients is because of COVID, we are testing everyone. So we don't want any strangers at all into our housing. So the best next step that you could take is to have an outbuilding or a space, you know, with some guard from inclement weather, for visitors to have an appropriate gathering, congregating platform where they can talk to workers. Remember, it's 1 hour after work, 1 hour before work, and then during lunch. The 1 hour after work is really at the production site. There's really no limit if they come into employee housing, okay? We would still enforce the 1 hour, but I don't know that we'd get anywhere, okay? All right. So dealing with strangers and visitors, first of all, conspicuously post your land and your production areas. No trespassing. Authorized personnel only. All visitors check in at the office for an escort. Food safety regulations in effect. Authorized personnel only. Intercept them. This is where we train our supervisors. Intercept them as soon as possible. Instruct security or supervisors at the point of ingress to stop them before they get into the work site. If they're already in the field, stop them immediately before they can go any further. There shouldn't be any moving vehicles that we can't account for in a high hazard area. Train all supervisors, foremen, and management employees to identify and stop all non-employees that are seen wandering the work sites. This happens in secondary operations as well, whether it's a packing house or a processing facility. You have to check in, you have to get a badge, you have to be scanned. We're going to take your temperature and we're going to give you an escort. You're not going to walk around a facility la-di-da like unescorted. Confirm identities, document the interaction. Ask for business cards. Get as much information as you can, names of these trespassers, or if they're from the government, get a copy of their card so you can text it to your boss. Get the purpose of their visit, who invited them on the property. We're gonna take pictures. We're gonna send them to the main office. Before we do, we're going to take their make, model, and license plates of their cars and get that over to our team. Okay? Always, always, always stop them from accessing the workplace immediately. Okay? Get them off the property, get them to a neutral location to be assigned an escort. If they don't want to cooperate, they are now a trespasser. The sheriff's office is your next call. Okay, and here's that cheat sheet, the unwanted guest cheat sheets, and we'll get you that into the Dropbox as well, English and Spanish, so you have it for your training. All right, unfair labor practice procedures. So we rarely do talk about ULPs with you over the years. I don't spend a lot of time on them because it's kind of out of a client's pay grade, right? That's what they pay us for. But since COVID, we've seen the Agriculture or Labor Relations Board being used by workers more often than the Labor Commissioner and OSHA to file their complaints, whether they're discrimination or, hey, I've been discriminated against and I'm making less money because of these COVID procedures. For some reason, they're getting more of a voice with the Agricultural Labor Relations Board. So let's just go through them. The types of ULPs typically surround discrimination because of union activities, a refusal to bargain, an interference with union organizing, or some curtailment of a worker and a group of workers from exercising their organizational rights to have a union and to talk about unions and to self-organize. Surveillance of employees engaged in concerted activity and or illegal boycott or strike activities. Remember that boycotts and strikes, depending on what form they take, could result in people losing their jobs, but that's not your call, that's your lawyer's call. Remember that secondary boycotts are legal under the Agricultural Labor Relations Act, one of the major differences between that law and the National Labor Relations Act governing non-ag operations. So the general counsel of the ALRB prosecutes on behalf of the charging party, typically either a union or a singular or group of farm workers. Hearings are held before administrative law judges. Those decisions can be appealed to the full board and beyond. Remedies in these cases include reinstatement and back pay or injunctive relief. Injunctive relief is telling an employer cease and desist from these practices as they have a negative impact or discriminatory impact on a group of workers or on a singular worker. So in a refusal to bargain case, we don't need to talk about that. That means you've already been certified, you're in bargaining, and you've been found to regressively or in bad faith bargain. We don't need to even talk about it. So when you have an unfair labor practice filed against you, you're going to get served, much like you will be served with a notice of intent to take access. Internal investigations are ill-advised. However, your supervisors in HR should have a plan nonetheless on how to conduct investigations before it gets to the attorney. So have a written policy in place on how to conduct investigations. Take all complaints very seriously, investigate them immediately. Designate a specific employee with a backup in case he or she is on vacation to handle these complaints. Use a trained, uninvolved investigator. We use outside investigators. That's what we have our labor management consulting firm for. And if it's more serious than that, we bring in a law firm that that specializes in investigations. Listen to both sides. Provide employees a fair and ample opportunity to present their position and correct and contradict relevant statements. Using an investigator, I know that there are HR companies around. That doesn't make them good investigators. A good investigator should be able to tell you how many investigations they have conducted and documented and how many of them have been used in court. That's a good investigator. There's a lot of HR hacks out there with their companies saying, oh yeah, we do workplace investigations. Really? Okay. Tell me about the ones you've done and what's your system? Because if you muck up an investigation, it could get a whole lot worse for you. So for that reason, go through your lawyers. We don't do the investigations for that reason. That's not what we do. Carefully consider information offered by both sides. Follow up and ask relevant fact-based questions during that investigation. Maintain confidentiality of the witnesses if it's possible. Inform the witnesses of the need for confidentiality. Remember that in agriculture, conducting investigations in private, maintaining confidentiality is very tough to do because we have so many people that we hire that are related to one another or are familiar with one another from Mexico. So you have to go a long way to ensure confidentiality. Confidentiality in an investigation, for me, is less important than retaliation. If I've got an investigation, for instance, on a sexual harassment, and I've got a young lady that says this young man over here said or did something, I'm going to begin that investigation, but I am sure as hell going to make sure that my HR team gets to her brother, father, uncle, or whoever related to her and let them know, look, if you hear about this, you can't take the law into your own hands, either in or outside of work. We've got it, we're investigating it, and we will make sure it's done correctly. Because the accused has as many rights and is afforded the same protection as the alleged accuser or victim, okay? It's very important to protect everybody's rights. Much more difficult to do in our agricultural environment because of these familial ties, okay? Take complete notes of the investigation, attempt to identify all witnesses and interview those witnesses, communicate to the employee the purpose of the questioning, assure the employee that no reprisal will take place, and we'll go through what we call Johnny's poultry declarations here in a minute. The questioning must be free from employer hostility and not be coercive. That's why we prefer that employers stay out of it. The questions must not exceed the legitimate purpose of the investigation at hand and no other interference with their rights. Encourage witnesses to contact the investigator if they think of any more information after they're done. Reach a reasonable conclusion and notify the complainants and the accused of the result of that investigation. So here's the things that we want to talk about. Let's go back here one at a time. First of all, you want to explain, and ultimately the way this works is this. You're going to talk to employees. From those, you're going to come up with a plan. You're going to come up with a list of questions, and you are going to go out and begin to talk to employees. The first 5 or 6 things that you are going to do is, first, you're going to tell them the purpose of the questions you're about to ask them, and that you're asking them to provide honest and accurate answers if they wish to be part of the investigation. You have to assure them that there will be no reprisals against them for participating or refusing to participate in the interview, or because of their responses to the questions. 3 bases on which you have to assure them that no reprisals will result. You have to get them to voluntarily agree to participate in the questioning and the giving of this declaration. You have to let them know that they can stop it at any time. You want an admonishment to them and them to understand, my employer is not here. I'm talking with an investigator. I'm talking with a lawyer. All of my responses are honest and accurate to the best of my personal knowledge. I'd end it there. The next sentence I would take out. We put it in there because it's been around for a long time as part of the admonitions, but I don't like threatening workers with perjury charges, okay? So Johnny's Poultry, Saki, what is this? It's a case. It's a case in 1964, and what they did, it doesn't matter the nature of the case. It was about an investigation for unauthorized gaining of signatures by a union. The lawyers for the company said, well, the only way we're going to find out what happened here is go and interview the workers and find out what context they were asked to sign cards, what representations were made, and are these their signatures? So they did that, and the NLRB came in, ultimately found out against them that they did it wrong, but in doing so, the NLRB laid out Johnny's Poultry for us. And they basically said, here's the safeguards to put in place to minimize the coercive impact of employer interrogations. You must communicate to the employees the purpose of the question. Assure the employees that no reprisal will take place. Remember, on that one, we're talking reprisals for participating, refusing to participate, or participating and by virtue of the answers they've given you. Obtain the employee's participation on a voluntary basis. Questioning has got to be in a context free of employer hostility to the union organization and must not be coercive. Must not exceed necessities of the legitimate purposes. And I don't want one-on-ones here. Last thing you need is people saying, well, it brought me into this room, Psaki interrogated me, I needed to go to the bathroom, he said, I'm not done with you yet, sit down. Now I've got a false imprisonment claim. Okay? You always want a team of investigators, at least 2. All right? And then it doesn't matter. So those are the 5 things that the board said. Okay? Doesn't matter how it ended, because it ended bad for that company because they did it wrong. But in doing so, the NLRB gave us Johnny's Poultry. And let's see if we have any questions. Okay. So that's it. We're at the point in the season where I'm trying to shorten up our bull sessions, get you what you need for what's happening out there. Right now, unions are not on the prowl as best as we can tell, but NGOs with Julie Sue are, from Oxnard, Ventura County through Santa Barbara County up through San Luis Obispo County, has not hit Monterey County, and I don't suspect that it will. We do believe that these will end in the next few days. In the meantime, we should use this as an example of tightening up our signage, tightening up our properties, and tightening up our supervisor trainings. I think that's what comes out of today. And learning how to do investigations and doing them right. Don't use HR companies that say just because they're an HR company that they do investigations. Proper investigations. I've got one company down in the Monterey area that we've got individuals that do investigations, and they are very poor. And I stopped using them because all the questions were leading. They were combative with witnesses. It's like, no, man, it's like you've got to be sort of like a priest or a psychologist when you're doing investigations. You answer open-ended questions and let people talk. Get it out. The more information, the better. If someone's lying to us, it's more likely by allowing them to talk without question after question after question after question, just open-ended questions and let them ramble, that if they are lying and making stuff up, we're going to catch them because they always change their story. Okay? So that's it for today. Stay safe, stay healthy, and have a safe season. We'll talk soon.